Ladies and gentlemen of the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. Today we will take up case number 22-1050, Planned Parenthood of Southwest and Central Florida versus State of Florida. Ready.
Good morning, Mr. Chief Justice and esteemed justices of the court. My name is Whitney Lee White on behalf of the plaintiffs.
I'm sorry, I'm having trouble hearing you.
Sorry, is this better?
Much better, thank you.
Whitney Lee White on behalf of the plaintiffs. May it please the court. For 4 decades, Florida's Constitution has provided strong, independent protections for the fundamental privacy right to decide for oneself, without government interference, whether to continue a pregnancy or have an abortion. Despite that, HB 5's abortion ban has been in effect now for more than a year, violating fundamental rights and subjecting pregnant Floridians to serious and unnecessary risks to their health and indeed their lives. Now the state is asking this court not only to allow these harms to continue, but to in fact hold that there is no protection for abortion under the Florida Constitution whatsoever, and indeed no protection for any decisional privacy rights at all.
Counsel, can I, I'm sorry to mess up your order, but can we start with standing? Could you describe a little bit what standard you think should apply here in determining standing, and then what factors you would meet as a third-party standing, first-party standing, if you could articulate that to start.
Yes, so I'll address first-party standing first. So the plaintiffs here have faced a clear injury in fact because they've been coerced under threat of government enforcement into complying with HB 5, even though it requires them to act in ways that are contrary to their professional judgment and contrary to their ethical obligations to their patients. With respect to third-party standing, I believe there's no dispute in this case about the 3-pronged test that applies for third-party standing. That is the test that the trial court applied, and the trial court found that for all 3 prongs, injury in fact, closeness of the relationship, and hindrance, the trial court made specific factual findings that plaintiffs had established each of those factors.
So is it Planned Parenthood's position that that federal standard for standing applies here and that we should apply it in this case?
Yes, Your Honor. I believe that's the approach this court has taken in numerous cases, including Altera Healthcare Corps, where the court has looked to federal law and generally applicable principles of third-party standing under federal law. If I could return to the question that the state has put before this court to overrule precedent, this court should refuse to do so for 3 main reasons. The first is the plain text of the privacy clause.
Can I stop you before you go there too? My question is about irreparable harm. Yes. And a showing of hindrance. It seems to me that the patients that you purport to represent a heterogeneous class of persons. They're not all the same. Can you identify what hindrance is common to all of the patients you purport to represent?
So, Your Honor, the patients that are at issue in this case are those who are in need of and seeking abortions after 15 weeks. And the trial court found that there are many factors common to that group that create hindrance. So first is the time-limited nature of pregnancy. These patients are patients who are already 15 weeks pregnant and are seeking an abortion and only have a set amount of time before they would irrevocably lose their ability to receive relief from a court.
Which, as the state argues, we've got a mootness doctrine about, right?
There is a mootness doctrine, but that doctrine doesn't affect the third-party standing inquiry. All the capable of repetition exception provides is a mechanism for a court to hear a claim after an individual has already irrevocably lost the ability to exercise their constitutional rights. And it's that risk of being forced to carry a pregnancy to term without being able to receive relief from the court that the trial court found specifically creates part of the hindrance for these individual patients. I also want to note that it has never been the case under this court's precedents that there has to be a showing of absolute impossibility in order for the hindrance factor to be met. In Altera Healthcare Corps, the court emphasized that the standard is whether there is some hindrance. And in cases like Powers versus Ohio, the U.S. Supreme Court specifically recognized third-party standing, even though they also acknowledged that there were rare occasions in which the individual jurors who were the third parties at issue in that case had brought cases to litigate their own equal protection rights, but that didn't, those sort of rare occasions didn't destroy third-party standing in that case. And so that's the standard that applies here. The trial court has found, in addition to the time-limited nature of pregnancy, multiple other factors that create a hindrance to pregnant patients being able to litigate their own claims here. I believe you also had a question about irreparable harm. And so did you just want me to speak about the showing of irreparable harm generally? Yes. The trial court found irreparable harm both to plaintiffs themselves and to their patients. With respect to the plaintiffs themselves, the trial court found that HB 5 would force them to act in ways that are contrary to their professional judgment and to their ethical obligations to provide care to their patients.
You're not arguing, though, are you that right or that capacity of a physician is part of the privacy right, are you?
No, Your Honor.
So
but
from whence the right of the physician to deliver care? Is that a constitutional right?
It's not a constitutional right, but it is legally cognizable, and it qualifies as irreparable harm because there is no adequate remedy at law for that. So in cases like State Board of Medical Examiner versus Rogers, this court has recognized that state action exercise of a physician's professional judgment constitutes a material injury. The trial court found that these injuries plaintiffs will face themselves have no adequate remedy at law, and the state has not suggested that there is
But for
one.
example, you would concede that that injury is not a fundamental right in the same way that you claim the patient's right is a fundamental right.
That's correct. We're not claiming a fundamental right on behalf of the physicians, although I would note that the harm that the physicians are facing themselves is related to the constitutional inquiry because the trial court found a likelihood of success on the merits, meaning that the care that physicians are being prevented from providing to their patients is care that is constitutionally protected and that their patients are constitutionally entitled to receive. And so while that doesn't mean that the physicians themselves have a fundamental right at issue here, I think it does color the inquiry and certainly underscores the irreparable nature of the harm.
Would you agree that none of this court's precedent in the context of abortion cases directly addresses the standing issue?
That is correct, that the court has not directly ruled on third-party standing as part of its abortion precedents. That being said, with respect to third-party standing, there are generally applicable principles that I believe are not in dispute in this case that govern the legal test that applies there. And that is the test that the trial court applied. With respect to how third-party standing intersects with irreparable harm, I would note that while it wasn't specific, it didn't come up in specifically the same way, there is a clear conflict with this court's precedent in Gainesville Woman Care, where plaintiffs who were identically situated to the plaintiffs in this case and were solely asserting privacy claims on behalf of their patients, the court affirmed a preliminary injunction based solely on the harm that had been shown to those patients. So there is precedent for injunctions being granted in precisely this situation. If I could return to the constitutional question, there are three main reasons that the court should not accept the state's invitation to overrule precedent and should affirm it instead. The first is the plain text of the Privacy Clause itself. It uses broad language, and it was adopted by voters in 1980 at a time when the established meaning of the Privacy Clause's terms unequivocally included the right to decide for oneself whether or not to continue a pregnancy. Second, in 2012, voters were presented with an opportunity to overrule abortion precedents by constitutional amendment.
Can you talk about the plain text? You present just kind of a textual breakdown, dictionary definitions, and that sort of thing. And so if we're looking at the text in a vacuum, why does it not connote a negative implication. It's the right to be let alone, free from governmental intrusion. And how does that square in the abortion context when it seems like your clients are seeking a right to procure something?
So I think that abortion is unambiguously covered by the plain text language of the Privacy Clause. The Privacy Clause refers to a right to be let alone and free from government interference into a person's private life. And private life includes not just private information, but private activities and private decisions. The trial court specifically found in this case deeply personal and private reasons that individuals need access to abortion care. And there's no basis in the text to exclude a decision as deeply personal and private as the decision of whether to continue a pregnancy from the otherwise broad protections for freedom from interference in private life. I would also note that under this court's precedents in cases such as voting restoration amendment, as part of the plain text analysis, this court has looked to contemporaneous case law interpreting the terms in a constitutional amendment to look for the established meaning of those terms at the time that they were adopted. And here in 1980, the general right of privacy and the specific terms used in the Privacy Clause were unequivocally had an established meaning that included a right of an individual to decide for themselves whether or not to continue a pregnancy. That established meaning is part of the plain text, and indeed the state agrees that looking to this sort of contemporaneous case law evidence is an important part of the constitutional analysis, and that's at pages 10 and 26 of their brief.
How would you respond to the fact that there is really virtually no sort of attention given to this subject in 1980? The state and all the extra briefs filed have put a lot of emphasis on what was in a newspaper, what people were talking about, what the legislature was talking about at the time. But your brief doesn't have very many supporting documents to show that that was the understanding of any voter in the state in 1980. Abortion's always been a divisive issue. It was divisive in 1980. Why is there not more that emphasizes your view of what that term meant at the time?
So first, Your Honor, I do think that the historical evidence is consistent with plaintiff's reading of the Privacy Clause, but I would also underscore that this court has repeatedly emphasized that when considering a question of constitutional interpretation, the plain text is paramount, and that evidence of individual subjective intent of drafters cannot override otherwise broad plain text of the amendment.
The plain text has an original public meaning, and I guess what Justice Groshand's question goes to is, if the original public meaning of that text included abortion, you would expect to see positions from Planned Parenthood and National Right to Life debating each other about it in 1980, and yet we don't really see that. How do you explain that absence?
I think there are a lot of reasons why individuals, for example, individual legislators who were not supportive of abortion rights might have nonetheless supported the Privacy Clause. There could have been a general acceptance that Roe was the law of the land at the time, and so the Privacy Clause, in incorporating that standard, wouldn't necessarily change things practically.
But you don't even see that. You don't even see op-eds saying, well, this is about Roe.
Right, but I think, Your Honor, I think my point is that the fact that it's impossible to really understand what exactly was going through individuals' heads at the time is one of the reasons that this court has cautioned against looking to that sort of evidence first and foremost. But I do think that the historical record here is consistent with plaintiffs' understanding. There's evidence in the historical record that legislators were fully informed and fully on notice that the terms of the Privacy Clause were broad, that they would incorporate existing federal privacy rights, and that included decisional autonomy rights such as abortion. Likewise, in the public record, in terms of media coverage, both opponents and supporters of the amendment repeatedly described it as being broad, as incorporating potentially incorporating decisional autonomy rights, as incorporating rights that already existed under federal law. And there was contemporaneous coverage in the news of a number of different abortion issues that repeatedly identified the federal right to abortion as rooted in the right to privacy. So there's plenty of evidence that is consistent with the original understanding and the original established meaning of the Privacy Clause to incorporate abortion rights.
Can I ask you about compelling interest? So on the sort of definition of the right side of the thing, of the scale, it seems like I think everybody agrees that that's kind of a fixed target, and we're kind of trying to figure out what that is. It seems like on the compelling interest side, though, that might not be the case, in the sense that, we've had in our country kind of a, 50-year debate over this. There have been changes in kind of scientific information. And, to the extent that it seems like the record at most shows that in a legal sense, privacy may have included abortion, but it doesn't seem like the people of Florida really had an actual debate over that when this was adopted. And they certainly didn't have a debate that would have resolved the question of how you balance the important interests here. So if we're talking about something as kind of fundamental as, the possibility of, protecting human life versus whatever the autonomy interests might be, how should our courts sort of look at our role in, overriding a legislative judgment on compelling interest that is not, this isn't heat of the moment, wartime internment or something like that. This is a 50-year reflection by our society, by our state. The people's elected representatives believe that there's a compelling interest in protecting human life. Why should we as a court not defer to that?
Yes, Your Honor. So with respect to fundamental rights, this court has repeatedly made clear that legislative deference in that context is inappropriate. The court's primary duty is deference to the meaning as incorporated in the Constitution. The Constitution, and in particular the rights afforded by the Declaration of Rights, act as restraints on legislative power. And when those rights are infringed, the state bears a heavy burden to justify the infringement. And it has never been the case that deference to the legislature is sufficient to discharge that heavy burden.
But the compelling interest test we wouldn't, if there wasn't some role for legislative judgment on that side of the equation, there wouldn't be a compelling interest test. There would just be kind of there would just be a standard of let's define the right and it's absolute, et cetera. We also have in the Florida Constitution, all natural persons are equal before the law and have inalienable rights, including the right to enjoy and defend life. I mean, the legislature, we have a constitution that, arguably speaks to sort of both sides of this. Why isn't the legislature the appropriate entity to kind of balance those considerations, especially where, I can understand sort of the role of the courts as sort of, protecting against some kind of, short-term frenzy or something like that. But when we have, a serious sort of moral debate on both sides with very, basic fundamental questions about, what kind of society we want to have and how we balance these things, why isn't the legislature in this particular context, especially when the people really, I was reading this Gerald Cope, who seems shockingly for a law student, seems to have been a pretty major player in informing the commission here that came up with this language initially. And he says on the decisional front, he says it's theoretically possible that the state right of privacy could have some effect in this area, but the point has no significance. He says as a practical matter, the field is so thoroughly preempted that nothing remains on which a state privacy right could operate. So obviously that doesn't take away the idea that there is some sort of underlying core there, but it definitely undercuts the idea that the people of Florida believed that they were, making some kind of decision about how we're going to, balance these very, profoundly weighty, serious interests on each side.
Yes, Your Honor. So I think there were a few points there, and I'll try to respond to all of them. So I think with respect to the compelling interest, it comes back to the established meaning of the Privacy Clause's terms at the time that they were adopted. In 1980, the right to privacy included a right to decide whether or not to have an abortion up until viability. This court has consistently held in abortion and non-abortion cases alike that the Privacy Clause, when voters adopted an express and freestanding Privacy Clause that had no analog under the federal Constitution, it provided greater protection for privacy rights than what existed under federal law in 1980. And it would simply be inconceivable that that would be the case writ large, and yet with respect to the issue of of abortion and the compelling interest, that there would somehow be significantly less protection here by allowing a compelling interest to override the privacy decision before viability. I think, with respect to the comments of Gerald Cope and about the field being preempted here, I think there's a couple of ways that that quote could be interpreted. One is that it could be speaking as a practical matter, that Roe already provided these strong protections, and so the Florida law would not necessarily, the constitutional amendment wouldn't necessarily change the impact on the ground. If it's a statement about the fact of there being federal constitutional protection, meaning that there isn't a role for states to play, I think that's simply incorrect. It's a core component of the federalist system that states are at liberty and have the prerogative to provide greater protection for individual rights than what exists under the federal floor, and that is precisely what Floridians have done.
Yeah, no, I think that, the ability of states to go beyond the federal floor, that's not in dispute. I think that, so much, a big theme of your brief is sort of deference to the democratic decision-making process. And I guess it seems like, to the extent that there really was a quote-unquote decision, it's very kind of abstract in the sense of, assuming kind of that people had kind of internalized the sort of legal understanding of a right of privacy, which I think you would have to admit is terminology that in the abortion context, it's not semantically a natural way to talk about it. It arguably kind of uses euphemism to kind of mask the reality of what the choices are that, people are having to face on both sides. And, I think one of the reasons why there probably wasn't a lot of debate over this is arguably because the people thought that the federal law had essentially made whatever Florida was going to do on this irrelevant. I'm not saying that that changes the meaning of what sort of privacy in general meant, but I do think that to the extent that your position is that there's some sort of democratic legitimacy here that we need to respect, I think it does inform sort of what that democratic choice looks like.
Mm-hmm. Yes, and so I think that when it comes to the democratic legitimacy point, there is both the moment in 1980 when Floridians adopted a constitutional right that didn't exist under the federal constitution, but the court also has subsequent information, including 2012, where voters were presented with the opportunity to overrule precedent in precisely the way the state is asking the court to do now, and to weaken protections for abortion rights under Florida's constitution. And voters rejected that, and they instead voted to retain independent protections under the state constitution for pre-viability abortions.
I understand why that part is relevant to the democratic discourse, but do you concede that that doesn't tell us anything about the original public meaning of the word privacy in 1980?
Yes, Your Honor. 2012 isn't evidence of what it meant in 1980, but I think where it becomes relevant is that under the stare decisis analysis that this court applied in Poole, there's a two-prong analysis. First, whether the prior decision was not simply incorrect, but whether it was clearly erroneous and not a reasonable interpretation for the prior court to have reached. And second, the court also pointed out that even if the court were to conclude now that a prior decision is erroneous, there may nonetheless be reasons to retain it. And one of those is societal reliance interests. And the Poole court suggested that the rule of law is one of those interests. And so here we have a situation in which voters through the democratic process were presented with an opportunity to tell this court that it had gotten its precedents wrong and to adjust them accordingly. And the voters refused to do that. And so I think that provides additional evidence weighing in favor of adhering to precedent now, because this court's actions overruling precedent now would be directly contrary to what voters decided to do when they considered this question at the ballot.
Can I ask you, so one way that courts traditionally have tried to kind of put some boundaries around vague language that, if read literally could kind of have meanings that, nobody would think is reasonable, is to adopt sort of a mischief rule analysis. If we were to look at this provision that way, what would you say is the mischief that this provision was understood to be addressing?
I think multiple things, and I think it's entirely possible for the original meaning to have encompassed multiple different ways of ensuring individual rights against government interference. Returning to the established meaning, freedom from government interference meant a number of things. It certainly includes the informational privacy protections that the state focused on, but it also included a freedom from government interference with deeply personal and private decisions that affect one's health, one's family, one's future, and abortion falls squarely within that protection.
But in terms I appreciate that answer, but in terms of the specific kind of history of our state, because obviously one of the kind of good and bad is, there is a privacy clause here, but it's also the product of a real kind of lived experience of the state of Florida. So is there anything kind of more specific from a mischief rule perspective that you could point to in terms of our state's culture and history in 1980 that can shed some light on the mischief that was being addressed by this provision?
Yes, Your Honor. So in several precedents leading up to 1980, this court had rejected the notion that there was a general right of privacy under the Florida Constitution. That general right of privacy in cases like Chevin and in Laird versus State, this court explained would incorporate the more limited privacy rights that existed under federal law, but would also fill gaps that didn't exist in federal law. And I think there's quite clear evidence that the privacy clause was intended to remedy that by creating a general right of privacy. And there's simply no reason to conclude that that general right would have excluded one of the core components of that existing privacy landscape. And in fact, in Laird versus State, when this court was surveying the existing landscape of privacy rights just 3 years before voters adopted the amendment, it referred to the statements of Roe versus Wade as being the definitive statement of law in this area. I see that I'm running well into my rebuttal time.
Go ahead.
And I want to make sure I have a moment we talked a little bit about the harms to plaintiffs themselves, and I wanted to close by focusing on the evidence of harms to plaintiffs' patients in this case that the first DCA unjustifiably ignored. I want to underscore that the first DCA's approach here would undermine the entire purpose of third-party standing and the court's inherent equitable powers. It simply would make no sense to have a rule that allows courts to hear third-party claims, but then forces them to stand aside when the threat of harm to those third parties is imminent and irreparable. And there can be no doubt, based on the record in this case and the trial court's findings, that the harms plaintiffs' patients are facing are indeed irreparable. The trial court found that HB 5 would force providers to deny and delay care to patients in ways that are antithetical to quality patient care, and that finding has been borne out by experience. I want to refer the court to the amicus brief filed in this case by Floridians for Reproductive Freedom, which documents numerous instances over this past year in which, despite their best efforts, providers are finding their hands tied by HB 5, and it is forcing them to wait for patients who are experiencing treatable medical pregnancy complications to deteriorate to the point of, for example, developing life-threatening conditions like sepsis before providers can intervene and feel confident that they can provide care under HB 5. In another case, a provider was forced to deny care to a 14-year-old rape survivor, a child who had already been traumatized by the assault and now had to bear the additional trauma of continuing a pregnancy against her will. These injustices have been ongoing for a year, and if this court doesn't step in now, there's an even more dangerous 6-week ban waiting in the wings. So for all of the reasons we've raised in our briefs, plaintiffs ask the court to reverse the first DCA and reinstate the injunction.
Thank you. And you can have 5 minutes for rebuttal.
Thank you, appreciate that.
Thank you, Mr. Chief Justice, and may it please the court. The Florida Constitution does not establish a right to abortion, and the court should overrule its precedents that hold otherwise. There's been a lot of discussion in the opening about Roe and whether it was incorporated essentially into the privacy clause, and I think I'd like to begin by focusing my presentation on that. I think consistent with the court's analysis in the Amendment 4 advisory opinion, what is paramount in this case is what the voters understood the privacy clause to mean. And there is no indication that the particularly technical sense of privacy that Roe used to derive an abortion right was adopted by the people, was adopted and understood by the people. There's no evidence that that usage, which was highly controversial at the time and disputed even by scholars who supported an abortion right. Henry Friendly, well, I don't know if he supported abortion rights. Henry Friendly couldn't get there. Lawrence Tribe couldn't get there, at least not in 1988. John Hart Ely couldn't get there before the enactment of the Privacy Amendment. And I think as some of the questions have highlighted, abortion is one of the most controversial issues in our society today, controversial and hotly debated. And there also was a debate about the Privacy Clause, and it is unimaginable, given that controversy, that there is that it would have included abortion, given the near absence of references in the public debate over the question. And that
Can you help us understand, I'm sorry to interrupt you, how should we go about the process of trying to figure out how a Floridian in 1980 would have understood the concept of a government intrusion into a person's private life?
Well, I think you should use the tools of constitutional interpretation that Your Honors established in Amendment 4 and figure out the ordinary public meaning of the text. And we've provided a variety of tools that the court can use to interpret what those words mean and what the people reasonably understood those words to mean. We've provided dictionary definitions. We've provided even an empirical analysis of.
I mean, you would agree that you can't really use a dictionary to find out what a person thinks is a governmental intrusion into my private life. I mean, there's no way that you could sort of splice together looking up a bunch of different words, and so I don't know that the dictionary helps so much. I mean, how can we? So one thing obviously is the sort of public debate over this amendment, and so you get into the kind of application versus meaning to the extent that that we believe in that distinction. I mean, what other than the dictionary, what are the tools? How are we supposed to figure this out?
Well, I think you should try to figure out what the meaning is. And look, in one way of looking at the interpretive question of the text that's before Your Honors is you have two different warring concepts, interpretations of what concept the people enshrined into the Privacy Clause. We think it was a protection against informational privacy, rights to seclusion. They think that it protected decisional autonomy. Those are two very different concepts and senses.
Although their position is that it's both. I mean, to be fair to them.
It is their position, and I don't think it really makes any sense because they are distinct concepts. And just in thinking about how we use words, I mean, words can have different concepts or distinct concepts depending on the context. The word bank can mean either a financial institution or it can mean the side of a river, but it doesn't mean.
The distinction in concepts here, because we keep talking about the right to privacy, but our Constitution also instructs us not to use titles and subtitles in the construction of the interpretation. And so I think your brief focuses on the to be let alone part and the kind of old soil that comes with that term. So is that where you're seeing the distinction in concepts, or is it something else?
Well, I think both halves of the Privacy Clause, and it's undisputed here, are sort of getting at the same thing. It says governmental intrusion into a person's private life. And I think that second half of the clause is what is most evocative of the informational privacy reading that we are urging to you. And there are several, I mean, I think just as a matter of common sense, intrusion, not interference, intrusion into a person's private life, which is what it says, are words that are historically associated with informational privacies, almost right from Warren and Brandeis's 1890 law review article. So it is not the case that the only established.
You don't want us to think that the people of Florida had internalized an 1890 something law review article and not Roe versus Wade. Roe versus Wade may have been an abomination. It may have been semantically absurd to talk about that in terms of privacy. But for better or worse, I mean, that was part of sort of our cultural kind of lexicon, right?
Well, fair enough, Your Honor. But I don't think that what was part of our cultural lexicon, and maybe Roe's holding was, but Roe's reasoning, the confounding legal alchemy through which Roe derived a right to abortion certainly was not. And our empirical analysis shows quite the contrary. Quite the contrary. The ordinary and popular understanding of privacy did not incorporate implicitly Roe. But even beyond that, I think what I'm trying to illustrate here is even if one assumes, and they're essentially assuming and urging you to adopt a legal meaning, we certainly, at the very least, have established an alternative legal tradition with which the words used in the Privacy Clause, which are kind of distinctive, really, they're not repeated elsewhere. We're not relying on the title, Justice Sass. So we're not, and I understand we can't do that under the Florida Constitution. There's an interpretive principle that says we don't do that in Florida. I get that. But the ballot summary certainly did use a right of privacy, and I think that is objective evidence about what the people meant at the time, that they intended it to be a right to privacy. And again, it says private life right there in the text. And so at a minimum, what we have identified is a competing legal tradition. And so if you're looking at legal meaning, I think that's at best a push, and we have our textual argument, I think, is much better. Contextually, the only exception that is expressly enumerated in the Privacy Clause is for public records. Public records, that's the only exception, which is context. I think that's evocative of an informational privacy.
That second sentence has always kind of baffled me because it seems like kind of a non sequitur in the sense that the first sentence talks about intrusions by government, and then the second sentence talks about public records, and it seems like once the government has the information, then it just becomes kind of I could understand if the first sentence had talked about dissemination or publication, and then you have something about public records. So can you explain just how these two things even fit together?
Sure. So an important part of the right of privacy, particularly as it existed at the common law, which had nothing to do with decisional autonomy, was a right to disclosural privacy, the right to not have information about you disseminated. And one of the things, especially that the public record shows that the framers of the Privacy Clause were intensely concerned with, was the government collecting records about the people and then potentially disseminating them. And so the function of the exception is to show that notwithstanding the Privacy Clause regulating that kind of governmental conduct, you can have a public records law that may require disclosure of information and reveal information about people that the government may have collected. And this is not just Warren and Brandeis in 1890, Your Honor. The Restatement of Torts in 1977, used language similar to the Privacy Clause in speaking of the right of privacy as it existed in common law. And I think this court most common, looks to the common law a lot more than it looks to, extravagant decisions by the Warren Court in interpreting language, I think. And that's what the court should do here.
I know. Can you go ahead? Go ahead.
I think one thing the state's brief really did not address is if we as a court adopt your legal approach to this amendment, it affects dozens of other cases outside the abortion context, dozens of other subjects that relate, I think, more to a decisional autonomy than to informational. That's 30 years of precedent, completely undone by this one decision, of which we've had no briefing, of which we've had, not really a lot of information on. How would the state address that?
I think there's a lot less to that concern than meets the eye, Your Honor. I mean, many of this court's decisional autonomy precedents actually, that outside the abortion context, really don't have their origin in the Privacy Clause at all. In one case, there's been a lot of discussion in the briefs about the Shevin case, decided in 1980, which as counsel correctly indicated, said that there wasn't a right to informational privacy under the Florida Constitution. The same day this court decided Chevin, it also decided a case called Satz versus Perlmutter, which recognized, even before the enactment of the Privacy Clause, that there is a right under the Florida Constitution to refuse life-saving medical treatment, a right of autonomy in your medical decisions, independent of the Privacy Clause. Ditto for the right to direct the raising of your children, which, this dates from basically a 1991 case called Paget that says nothing of privacy or the Privacy Clause and relies, in fact, on more ancient principles that predated the existence of the Privacy Clause. So I think that the Perlmutter case in particular illustrates an important part of the legal backdrop to the extent we're attributing to the voters sophisticated understanding of that legal backdrop. But let's go there. At the time the Privacy Clause was enacted in 1980, the state of the law was we had Chevin, which said there was no right of informational privacy, and we had Perlmutter, which said that there was a right of decisional autonomy directly under the Florida Privacy Clause. And it would be pretty odd, I think, whatever the state of federal law, and we can argue about that, this is ultimately a question of state law, and it would be odd, I think, to attribute to the voters an intent to duplicate, essentially, what this court had already held was independently protected under the Florida Constitution. And I think that it makes it actually quite plausible that what the people were trying to do, they were trying to broaden Florida constitutional law, but in a relatively narrow and cabined respect. And with respect to my to opposing counsel, I don't think it's tenable to read the text of the Privacy Clause in the expansive way that they do. They say that it enshrines, basically, it is a charter of non-interference in any kind of a personal decision, which this court has never interpreted the Privacy Clause to sweep that broadly, and the consequences would be striking. I mean, I'm sure that my friends on the other side would not take this position, but they do not provide a limiting principle to distinguish abortion from infanticide, from euthanasia, from spousal abuse. Those are all involved personal decisions that I suppose the government could be said to be interfering with in some sense when the legislature takes action to remedy choices that harm others.
Can I ask, I looked at the briefs in In Re TW, and I haven't looked at the briefs in the other abortion-related cases that the state of Florida has litigated, but I know that in In Re TW, which was 9 years after this became law, the state of Florida didn't take the position that Section 23 only applied to informational privacy. They kind of accepted the premise that decisional, quote-unquote, privacy was part of it, and they were trying to defend the law kind of within that framework. At what point did the state sort of shift to the position that you have now? Is this the first time in one of these abortion cases where the state has argued for an information kind of scope for Section 23, or from the state of Florida's perspective, has that been the state's position earlier than this case?
I can't think of an instance where we've taken this position before, and I did go back and look at some of the briefs in Re TW, and I do believe that there were briefs that the court had in front of it.
Yeah, I'm just asking about the state of Florida.
I'm not aware, Your Honor, quite frankly. I mean, when this issue came up and before us, we did take a fresh look at this issue. I mean, and I think it's fair to say that the kind of historical evidence that we've really done a deep dive into the historical record, and what it shows, I think, is pretty striking about the historical backdrop behind the enactment of the Privacy Clause. I mean, what it shows that in the vast majority of cases, the Privacy Clause was explained and sold to the people solely in informational privacy terms. And I think that's quite significant, because if it really were the case, and not exclusively, there are some instances where decisional autonomy was mentioned, but in many of those instances, in the articles in which those appeared, you also saw the sponsors of the amendment saying, that's not what we meant at all. That's not what we're talking about. That's off the wall, that it would regulate intimate conduct, that it would regulate drug use. Those are the two examples of decisional autonomy that repeatedly came up. And I don't think my friends are arguing that the Privacy Clause protects drug use. Maybe they are, I don't know. But those are the two examples. But the sponsors repeatedly, again and again, came back and said, that's not what we meant.
Can we shift gears just a little and talk about standing? It's not really the subject of your brief, but what do you think is the doctrine that we should apply to determine standing? That's question one. And following up on that, why does Planned Parenthood not meet those standards?
If you're talking about third-party standing, we're comfortable with the court's decision in Altera.
So you think we should apply the federal standard?
We're quite comfortable with that because we think we win, and we did make a standing argument, and we have focused certainly on the pressing merits questions that are in this case, and certainly that's the direction we would urge.
But you conceded one plank of the standing analysis below, didn't you, about the closeness of the relationship between doctor and patient?
We did concede that, Your Honor, although we only need to win on one. One is good enough. And the prong of the third-party standing analysis I would urge the court to focus on, if the court is interested in that, is the hindrance prong. I do think that there's a lot of water under the bridge since the Powers decision in 1991. We have the Kowalski case from 2004 from the U.S. Supreme Court, which relied on, I think, just a few instances in which the right holder, that was a case about the right to an indigent defendant who pleads guilty to have paid counsel on appeal. And the court said, despite the fact that what we were talking about was indigent defendants, well, there isn't a real hindrance because there are plenty of examples where there actually are suits by these indigent defendants, and so that prong is not satisfied. And I would commend to Your Honors the recent decision of the Kentucky Supreme Court in the Cameron case, which
their constitutional provision is a little different from ours, though, isn't it?
Well, it is, but as I read the Cameron case, they in essence apply the federal standard. And one of the things the Cameron case observes is that the U.S. Supreme Court in Dobbs, and this wasn't obviously the main thing the court decided, but did throw a lot of shade on the U.S. Supreme Court's third-party standing cases in the abortion context, citing approvingly, Justice Thomas's and Alito's dissent in the June medical case. And one of the things that those dissents outline is that many examples in which women challenging abortion restrictions have been able to bring suit. The First District cited another of those examples, and I think those are decisive. And look, and I do not deny that women who seek to challenge an abortion restriction may have arguments that they face irreparable harm, but that's what TIs are for.
Speaking of irreparable harm, how do we square that standing position with this court's precedent on irreparable harm? We have 3 cases now saying that this class of litigants is irreparably harmed in the context of this precise issue, almost. If we issued an opinion in this case saying that there's no standing and stop, how does that opinion stand with the rest of this court's precedent in the abortion context?
I don't think in those prior precedents, Your Honor, that you squarely addressed the irreparable harm question that the First District has teed up for you here, which is kind of assumed. And I don't think the state made this argument that we're making now based on irreparable harm. And I do think it is.
But that's the conflict, right? The conflict, at least alleged, is that the first CCA's irreparable harm analysis was inconsistent with this court's analysis in Gainesville's Women Care.
That is the alleged conflict, Your Honor. We told the First District we didn't think there was a conflict. And look, I think what the point I'd stress is that even under third-party standing, you still need to show an injury in fact. I mean, and the reason is third-party standing is not simply a doctrine that permits one litigant to sue on behalf of another. Rather, it's a doctrine that allows a litigant who wants to assert his own type of claim to dispense with the ordinary rules that say you can't assert the rights of someone else. There's always the requirement, for example, of injury in fact. And there's also a principle that the remedy follows the injury. The purpose of remedies is to remedy an injury. So I think it's entirely logical that in asking whether a litigant who is asserting third-party standing on behalf of the others, the relevant question in asking whether a TI should be granted is whether that litigant has asserted an irreparable harm that will remedy the particular injury in fact that the litigant is bringing before the court.
Do you think that this court should view standing as jurisdictional or prudential?
Your Honor, we haven't taken issue with this court's precedents on that, which, consistent with the Page case from 2020, currently hold that standing is not a jurisdictional issue, it's a waivable issue. We have no quarrel with that, and we haven't presented any other arguments. I understand that I think the Secretary of State in another case presented a different view, but we haven't taken that on here, and we would ask the court to apply its established precedent on that. And the one thing I think that's a complicated question, and I would urge the court to steer clear of that in this case. We do think that the court can assume for the sake of argument that the plaintiffs have standing here and instead reach the merits. And I would just say that I think is what the court should do. I mean, after the Supreme Court decision, the U.S. Supreme Court's decision in Dobbs, the only thing that is between the legislature and regulating abortion in the way they would like are this court's precedents. And obviously, you have a 15-week law in front of you. As plaintiff notes, there's a 6-week law right around the corner. And I think the continuing vitality of this court's precedents on abortion is an issue that cries out for resolution by this court on the merits. And I think and Chief Justice Muniz, you're certainly correct. The state hasn't raised these arguments before, I think. I think that's correct. But I do think it's fair to say we've raised substantial reasons why there is, in fact, no abortion right under the Florida Constitution that haven't been presented to this court before. For example, one of the pieces of evidence that's never been presented to this court, as far as I am aware, is that dozens of the legislators who put the Privacy Amendment before the people in the 1978 and 79 legislative sessions voted to convene a national pro-life convention to add a pro-life amendment to the federal Constitution. The same legislature that put the Privacy Amendment before the people enacted abortion restrictions that were later struck down in the name of the very amendment that they asked the people to ratify. And the lead sponsor of the Privacy Amendment in the Senate explicitly disavowed on the floor of the Senate that it had anything to do with abortion. And I do think that that is objective evidence that the people never would have understood that what they were ratifying had anything whatsoever to do with abortion.
How should we, and I think that that's all important, but at the same time, in 89, we had Ben Overton, who was the chair of the CRC in 78, who said that abortion was one of the issues subsumed within privacy. We have Ehrlich, and I can't remember, basically all the justices who were much closer in time than we were, and they weren't a bunch of, William O. Douglas types. I mean, you don't get the sense that it's an ideological thing. It just seems to have been taken as a given that they believe that was, the baseline. How are we in a better position than they were to understand kind of what the common understanding of what the right was?
Your Honor, I think that Justice Overton seemed to be a smart man. I think he was probably a good guy. I don't think that his opinion, with all respect, reflected how the people reasonably understood what the words of the amendment meant. And he may have had, I don't think that Ben Overton's or John Mills' secret understanding of what the Privacy Amendment meant is what's controlling. And I'm not sure that Justice Overton had before him all of the evidence that we have marshaled in that regard.
Can you talk about compelling interest? Because it seems like that is, to me, it seems like that should be a moving target. And we also have a long tradition in Florida, which I don't think that you guys have emphasized that much in your briefing here, of this court almost taking kind of, at least rhetorically, adopting almost like a, a Thayer type position of, things have to be, beyond a reasonable doubt, unconstitutional, that sort of thing. Is that something, I know it's kind of touched on in your briefs, to the compelling interest part. I mean, could you elaborate on that?
Sure, and I would just say that we very much embrace the Thayer idea that an act of the legislature should not be struck down unless it is clearly unconstitutional. We rely on that principle in the brief, and I think that is something that goes into the calculus about whether to overrule precedent. That inquiry has to be done against the backdrop of that rule of deference to the legislature. And I do think that we would win under compelling interest as well, and that you can consult, you can certainly consider changing circumstances and the like. One thing I would like to stress about compelling interest is that we've obviously urged a rethinking of the court's privacy clause precedents, even taking them as given, though. I mean, this court has not rigidly applied means and scrutiny under the privacy clause. It's not really, as this court has applied it over the years, strict scrutiny in the strict sense, if you will. I mean, even as early as Winfield in 1985, which upheld under strict scrutiny a subpoena by DBPR of bank records in the context of a gambling investigation. It said that satisfied strict scrutiny. When this court in the early 90s was faced with three different privacy clause challenges to statutory rape laws, this court relied on strict scrutiny, and I think it was fair to say a relaxed form of strict scrutiny, to say that the state has a compelling interest in advancing the welfare of children, although the statutory rape statute lost in one of those cases. And I think and so too with the court's assisted suicide case in McIver in 1997, where this court upheld the legislature's statute criminalizing assisted suicide under a form of strict scrutiny that I think it's fair to say is not as strict as it's understood to be in many other contexts. And here we think that the state has a compelling interest at all stages of pregnancy in preserving life. And whatever you think about the status of an unborn life at any particular stage of pregnancy, it is a life in some sense, and it is unquestionably extinguished by the abortion decision, and the legislature was entitled to take that into account in legislating. And I understand the plaintiffs have raised substantial concerns about women who need to have abortions, suffer barriers to getting abortions, and terrible things. And the legislature weighed and balanced those concerns against the interest in preserving life. And that kind of weighing and balancing is precisely the kind of thing that should be done by the legislature and not this court. And that's what we would ask this court to do. Are there further questions? I'm happy to sit down if the court has no further questions.
Thank you very much.
Thank you. There are a few points that I want to try to respond to, and I'll try to move relatively quickly. The first is there was a question about what tools the court uses when looking to understand what voters understood. And the Voting Restoration Amendment case provides a clear example of that. Part of what the court did in determining what the ordinary understanding was likely to be was looking to contemporaneous case law as part of that plain text and ordinary meaning analysis. Here, the contemporaneous case law in 1980 unequivocally provided protection for the right to abortion as part of privacy rights and the privacy clause's terms. I would also underscore that the question here, in light of the stare decisis analysis, is whether the prior conclusion that abortion was included was clearly erroneous. And here, in light of the plain text evidence and in light of the established meaning in 1980, it was at minimum reasonable for the prior justices of this court to include that it was. And that counsels in favor of this court adhering to precedent. In fact, not only was the TW court unanimous in concluding that the privacy clause protected abortion at least as strongly as under Roe, no justice of this court has subsequently written a decision calling that conclusion into question. And I think the weight of those considered judicial judgments provides clear evidence that the prior conclusions were indeed reasonable and fall far short of the clearly erroneous standard. I also want to address the state's argument to limit the clause solely to informational privacy. This is a completely atextual reading of what the privacy clause said. The state would have this court read it as if it protected private information from government snooping, and that is simply not the words that the privacy clause uses. In cases like voting restoration amendment, the court refused to narrowly construe the phrase terms of sentence to exclude legal financial obligations where the text itself doesn't do so, and that's precisely the case we have here. Nothing in the text excludes decisional autonomy rights like abortion from the otherwise broad protections. The state mentioned the second sentence, and I just want to underscore that voting restoration amendment also dispenses with that argument. That case made clear that a specific term only narrows a more general term where it precedes it, and that is not the case with the privacy clause. I want to speak for a moment also about the implications of the state's argument that the clause is limited to informational privacy. As the questions recognized, this would have a destabilizing impact on numerous other areas of this court's privacy jurisprudence. This court has repeatedly applied the privacy clause outside of the informational privacy context in areas such as parental rights and medical decision-making. Many of those cases did rely specifically on first and foremost on the privacy clause under the Florida Constitution, not under the federal protections. And moreover, this court has repeatedly held that the privacy clause is broader and more protective of those rights than federal law. So the Florida Constitution's protections for decisional autonomy are not at all duplicative of federal law. And if this court were to accept the state's argument, it would have a destabilizing effect on all of those other rights that this court has held to be independently protected by the Florida Constitution. With respect to standing, I wanted to note that the state referred to the Kowalski decision, and I want to underscore that that decision specifically emphasized that in certain contexts, in particular where a third party's rights are harmed by the direct enforcement of a law against somebody else, in those circumstances, the third party standing inquiry is more forgiving. So if anything, Kowalski makes clear that in a circumstance like this, where the providers themselves are the ones that are directly subject to HB 5's severe criminal penalties and have a clear stake in the outcome of this case, the third party standing inquiry, if anything, is more forgiving, and the trial court's findings that plaintiffs satisfy it is more than sufficient to affirm. I lastly just want to address the state's suggestion that upholding privacy rights for abortion here would open the door for other things like infanticide. And frankly, there's no reason for the court to be concerned about that. This is not a brave new world. Abortion was recognized as a fundamental privacy right in Florida for decades. It has never been the case that has led to a free-for-all of according privacy right protections to criminal acts like infanticide. There's also a clear basis for this court to distinguish because the privacy clause was unequivocally included in the established meaning, and that is simply not the case for these other extreme hypotheticals that the state has put forward. So for all the reasons...
Sorry, can I ask you about Dobbs before you finish? So you're asking us to essentially take a whole class of human beings and put them outside of the protection of the law, essentially in the sense that if the legislature wants to protect those human beings, they are precluded by the Constitution of Florida from doing that. And at the end of the day, the argument as to why that would be right would be based on a sort of legal meaning kind of understanding of right of privacy. We now know that, the same entity that created that understanding of the right of privacy has told us that it was a mirage. They've eviscerated it. Should we take that into account when we're talking about the weighty interests at stake on both sides and the fact that this is a sort of democratic legitimacy type issue? Should it matter to us that the entire foundation of the asserted right here, essentially the Supreme Court, which created the thing in the first place, has now said that it was egregiously wrong from day one? I mean, should that matter to us?
No, Your Honor. And there are 2 points that I want to raise. First, I think I want to underscore that what would in fact be unique here is allowing HB 5 to stand, because there is no other context in which this court has held that the state can constitutionally force an individual to take on increased and serious medical risks and harm for the purported benefit of others. But that is precisely what HB 5 forces pregnant women to do. The protection for privacy rights in this court's precedent do balance those interests and recognize the state's interests in fetal life after the point of viability. With respect to Dobbs specifically, nothing in Dobbs, on its face, the court repeatedly emphasized this, nothing in the Dobbs decision displaces pre-existing state constitutional protections for abortion that were more protective than the federal law. And Dobbs repeatedly makes clear that indeed that's a core part of our federalist system, that states are free to accord that level of protection. And that is precisely what Floridians have done here. So for those reasons and all the other reasons stated in our brief, we ask the court to reverse the first DCA and reinstate the trial court's injunction. Thank you.
Thank you. We really appreciate the excellent argument and briefing today. We're adjourned.
All rise.